Welcome to the Litigation War Room, where you will hear great stories and great insights to raise your litigation game and win more cases. Here's your host, litigation attorney, Maxwell Goss.
Shane Reed, welcome to the Litigation War Room.
Thank you, Max. Glad to be here. Appreciate the honor of being on it.
Well, I really appreciate your making time for this podcast. I'm really excited to have you on today. We're going to be talking about deposition strategy, practice, technique. You've written extensively on the subject and spoken, and I know you give seminars and training on these things. I have in front of me your awesome book, Winning at Deposition, which I've got on my shelf, but it's not just on my shelf. I truly do refer to this book regularly. I've also got your book, Winning at Cross-Examination, as well. And when I was preparing for this podcast, I saw you had a book that I was not aware of called Turning Points at Trial, where you have contributions by people like Mark Lanier and Alan Dershowitz and others. And so I've ordered that and look forward to reading that one. So you're a real thought leader and seasoned pro in this area, in the area of trial practice. And I'm just really excited to have you on the podcast.
Well, that's one of the nicest introductions I've had. So thank you. I appreciate it. And Max, I've heard so much about your podcast and very glad to help in any way I can to be a part of it.
Well, thanks so much. I just wanted to start by asking just a little bit about your background. Reading your bio, I saw that we have one thing in common. It said that you started your legal career at Aiken Gump. I started at Aiken Gump as well. I was in their San Antonio office. Were you, I believe you're based in Dallas. Did you start in their Dallas office?
Correct. So first 3 years were the Dallas office, then off to public service at the U.S. Attorney's Office in D.C. for about 6 years, and then another 24 years in the Dallas U.S. Attorney's Office doing civil defense work for the federal government, and then also white-collar prosecution. That kind of summed up the trial lawyer part of my career. At the same time, I was being an adjunct professor at SMU on trial skills, and then writing these textbooks that you mentioned and a couple more, and teaching lawyers and doing that. And then I guess a year ago, I left the U.S. Attorney's Office to be a full-time trial consultant to lawyers on trial strategies and jury selection, and also training at law firms on the books I've written on trial skills and deposition skills.
Well, hopefully our discussion today will give listeners at least a taste, a preview. I do have a lot of questions for you, but I know we won't exhaust all of your knowledge, so it'll hopefully whet listeners' appetites for your books and for your training. One of the things that I want to do on this episode, as you know, is talk about some clips. I know that in your teaching and in your books, you refer to a lot of actual deposition testimony and trial testimony, and we'll come back to that. But I wanted to start with a few questions of a more general nature. You have said, I might be paraphrasing here, but basically that depositions are the new trials. Can you expand on that and tell us what you mean by that? And also tell us if I misquoted you.
You didn't misquote me. The science just backs it up, Max. As you all know, 92% of our civil cases are settling. It's maybe 90, 92, depends on the year. But over the last 20, 30 years, that's the statistic. The idea that you can take a deposition, correct it later, it's always something that's fixable at trial or at some other moment. It's just not true anymore because our cases do settle. And one of the most important things I tell lawyers is that a deposition testimony equals trial testimony, and to treat it that way.
Yeah, absolutely. I mean, this is something I tell my clients all the time. I was just counseling a client on this very topic yesterday, that depositions are where the action is at these days. Something like 1% of all cases get to an actual trial, at least in federal court. The action is really, that's really where it happens in depositions. And if a case hasn't settled by the time depositions roll around, often the writing is on the wall after those depositions as to which direction the case is headed and can help facilitate a resolution.
Of course. Yeah, I agree completely.
I just want to pull a few insights out of your book. I was kind of rereading your book, Winning at Deposition, preparing for this episode. And you have some sections. One's called, I think, 8 Reasons to Take a Deposition, and another one called 5 Reasons Not to Take a Deposition. You don't necessarily have to go through all 8 and 5, all 13 of those bullet points, but in a way, it's counterintuitive to say there are reasons not to take a deposition. So I'm just wondering if you can comment on that a little bit. Like, one, what are some of the reasons one would take a deposition? And then why might one not choose to take a deposition?
Yeah, I'm glad you're not quizzing me on the exact list of the reasons to take it and not to take it. But I would say that the single most important reason to take a deposition is to size up the witness's credibility that you're deposing. Because even if it doesn't go to trial, that's how you value the settlement, right? We've got facts, we've got exhibits and documents, but is that person going to be believable or not believable at trial? At a deposition, that is one of the key things I've got my radar up for. Not necessarily their answers, which are important, but are they believable? How would a jury perceive them? That's a huge reason to take a deposition.
Yeah.
A second reason is you want to preserve testimony if that witness is not going to be available for trial. So you need to be thinking about that. Every time I walk into a deposition, I'm thinking, will this witness be available or not? And it will focus my attention on what questions to ask or not, because I'll know whether that witness is going to be available. And the third reason, I'm looking for some gold nuggets, just a couple. Robert Bennett, who I interviewed at Turning Points at Trial, he was Bill Clinton's attorney.
Yeah.
He told me that in a full day deposition, all he's trying to do is get 3 nuggets that he can use at summary judgment or settlement conference or trial against that witness. A lot of lawyers think, oh, I've got to get 20 or 30 great things out of this witness. Well, good luck. If you can get 3, you've won the deposition. So I'm just listening for an outrageous answer, an exaggeration, something I can impeach them with. And those are kind of the 3 things I think about when I'm trying to take a deposition.
One thing that I noticed you didn't say was to gather new information, gather discovery. So I'll play devil's advocate here. Isn't that what depositions are for? Is to learn some new facts?
Right. So that could be number 4 or number 1, depending on where you are in your case. So I'm glad you added that. Right. You want to learn. Wendell Turley, who I also interviewed at Turning Points Trial, he said it's a rush to disclosure. So his whole goal for depositions is to find out the good, the bad, and the ugly about his case. Because the sooner he finds out it's a good case, he knows where to go. And the sooner he finds out he has a bad case, the sooner he's going to settle it and move on to something else. And so Max, you have a great point. Yeah, discovery, I guess I was kind of assuming, but yeah, that's huge. And that's what you're trying to do, is discover as much as you can about your case so you can be efficient in getting it resolved.
Well, and I was playing devil's advocate a bit too, just to kind of take your temperature on that, because going in and getting those nuggets is so important. You want to know what those nuggets are, good or bad, early as possible. You want to collect those nuggets for yourself. But if there's some landmines out there, to vary the metaphor, certainly want to know what those are as early as you can, right?
I agree completely. Yeah, that's a great point.
There's Mark Lanier, a very famous trial lawyer who I know also is one of the contributors to your book, tells a very funny story about how he had to examine the CEO of an oil company. And, had to fight to get the deposition, had to, argue the Apex Doctrine and all that stuff, and tells this whole story about how then he finally, wins this battle, flies out to wherever this CEO is, goes up the elevator, shows up, according to his story, in T-shirts and a T-shirt and jeans and sandals, and sits down and essentially asks a question. The CEO gives him the answer. That's the answer he needed. That's what he was looking for. He said, "Thank you very much," and packed up and walked back out. That's sort of the optimal, the ultimate, and the efficient deposition, right?
Right. And that story is Mark going in. He's taking Ernest Cannon, his mentor, is taking the deposition, and Mark is helping Ernest Cannon take it. And they're taking the CEO of the oil company, and Mark Lanier, and Ernest Cannon's client, had slipped on oil and on the oil rig and had dislocated their back very badly. So the question that you're talking about is perfect, because the whole teaching point is know what you need to get out of a deposition and get it. And Ernest Cannon and Mark Lanier walk into the deposition and ask the CEO, wouldn't it be dangerous to have oil on an oil rig? And he says, yes. And then if there's oil on the oil rig, isn't there a chance someone's going to slip and fall on it? And he says, yes. And that's it. In the deposition, and they move on. And it was just that simple. A lot of us lawyers, including myself, we get lost in the details.
Yeah.
I take a full day deposition and never just get to that simple point. Hey, you need to clean up oil to make it safe.
Right. Yeah. Another great example. And we don't have to digress on Mark Lanier all afternoon, but yeah, I think the way that Ernest Cannon put it was, look, if you want to go take a TV out of a house, you walk through the front door, walk in and take the TV and walk out. Why dilly-dally? Why, poke around at the windows?
Exactly.
Do what you need to do, get in and get out, right?
Yes, that's
Yeah.
right.
I have taken that wisdom to heart many times. I wish I could say I've done a one question deposition. I've not achieved that just yet, but it is a good antidote to that inclination often that we have to just, this is my one shot. I don't want to miss anything. I've got 7 hours plus breaks. So I'm just going to sit and ask question after question after question.
Right.
Now,
Sure.
apart from wasting the client's money, do you see that as counterproductive in any way in taking a long, exhaustive deposition?
Well, Max, that's a good point. A lot of people think, well, I'll wear the witness down, and at the end of the day, I'll ask the tricky question, and they'll slip and make a mistake and answer it. And I guess that could work sometimes. The problem is if I do something like that, I am going to be exhausted, and I'm not going to be performing well at the end of the day. So I never get around to slipping in a tricky question that they're going to accidentally answer incorrectly, and then I get a win. So it doesn't work for me. I don't think it works for most people. And I just think it's not efficient because, Max, we all know, right, if we take a full day deposition, who's got to review that deposition? Right? It's us.
Right.
And that's going to take more than one day to review. So it's really inefficient. I think the game, a well-prepared witness is not going to slip up. And even if they slip up, right, the other attorney gets to ask questions at the end of the deposition.
Yeah, that's right.
They can clear it up. Hey, Mr. Witness, what did you mean to say when Mr. Reed asked you this? End of a long line of questioning. Oh, yeah. And then they explained it and they cleared it up. I think it's a bit more of a myth that works. But a lot of people follow that belief.
Well, let's talk about the flip side. What are some reasons not to take a deposition? Again, it kind of goes to that fear that I think many attorneys have of just not wanting to leave anything on the table, or that fear of missing something. So when would you choose not to take a deposition when you would otherwise have the opportunity? Well,
there's some of them are the negative of what I said earlier. So one reason to take a deposition is to preserve good testimony. Obviously, the opposite of that is if you take a deposition, you have now preserved the testimony. And if you have preserved bad facts for your case, they are now under oath that they otherwise would not have been, and maybe used at trial against you, but they may not otherwise have been. So that's one reason. Secondly, and these are kind of tied together, when you take a deposition, there's no way for you to ask questions that won't reveal your trial strategy.
Yeah.
So the other lawyer, you're educating them about what your case is all about. That's not a reason not to take a deposition. Just be aware of it. And when you go in there, you're going to reveal your style. That witness is going to be getting comfortable with you. And so when you cross-examine them at trial, they've seen you before, so you'll lack that surprise of your angle. And those are the two main reasons not to take one. And I guess if I had to add a third, which I always like to kind of group them in three. Max, if I say, hey, I want to take 10 depositions of your client's witnesses, well, what are you going to do? You're going to take 10 of my depositions. So there's a bit of warfare going on. So if you notice 10 depositions, you're going to be defending 10. And there's a reason maybe just to sit quietly and see what the other side does, depending on who you represent. And you may avoid having to take as many depositions or defend them. Not that you're scared, but it might help your case if that's a benefit to you.
So many good points in there. You raise the issue, among others, of revealing your trial strategy. And again, that's something that I talk to clients with from time to time. I'm sure you do as well. You always have to make this decision about sequencing. You don't have 100% control over the exact sequence, especially vis-a-vis the other side's depositions. But sometimes we think, okay, we're going to save the big kahuna on the other side for last after we get all the information and everything else is out of the way. And that can be a perfectly good strategy. But I think sometimes we have to keep in mind that they're going to be really prepared, by that time. And that when we do take it, an advantage of doing it that way is they're going to see our whole strategy laid out, if it's one of those long depositions, right?
Right, Max. And when I'm trial consulting, that's one of the first questions I ask is let's don't just take depositions in an order that's convenient for the witnesses or the lawyers. That is the last priority. There's a trial strategy to what order you take it in. And it can differ on the case, but you need to think it through and have a strategy. For example, if it's a med-mal case, you have the choice to start with the nurse and work your way up to the treating surgeon and the expert witnesses, or vice versa. And Max, what you were talking about is it may be very smart to go after the treating surgeon first, because if you do the treating surgeon first, the other lawyer hasn't been educated on all your facts. They're able to prepare that surgeon,
right.
The questions you're going to ask. But at other times, as you said earlier, maybe this is a discovery deposition and you need to figure it all out. So you ask the nurse all the questions and you build your way up to the surgeon, because you don't want to not ask a surgeon the right question because you haven't discovered enough information to know what is exactly the turning point in the case. My whole big point is you need to have a strategy, think it through. And it may be the wrong strategy, but at least you've thought it through and you've got a plan, as opposed to what most lawyers do. Hey, Max, we each want to take all these witnesses. Let's find out what their schedules are, and we'll do them what's convenient for the witness and ourselves. Well, that's not a good strategy.
Yeah, and you sort of get carried along by circumstance. And sometimes you can get played by the other side if you do it that way too.
That's a good point. Yes.
Yeah. Let me ask you this. One thing that you emphasize in your books is the importance of preparation. Like the Boy Scouts motto, be prepared. Shane, you're a super seasoned trial lawyer on both the civil and criminal sides. But what do you do when you're preparing to take a deposition?
One thing that always stuck with me, I interviewed with Frank Branson. He's one of the leading plaintiffs' attorneys in Texas and the nation. And he told me that if he has a 7-hour deposition, I want your listeners just to think about this. How many days do you think he spends preparing for that deposition? I think most people would say they spend 1 day, maybe 2 days. Frank Branson says if it's a 7-hour deposition, he's going to take 7 days to get ready for that deposition, because he wants to be the most prepared lawyer, but he also knows that it's trial testimony and not just another deposition. And if you think about that, who would walk into a courtroom and say, well, I just spent a day getting ready for this?
Yeah.
No one would. But we need to treat depositions like they're a trial, because they really are, and they're that outcome determinative. So it doesn't have to be exactly 7 days. Obviously, it depends on the witness. But it's an exhaustive preparation, and that makes a difference. Too many of us, and I did it early in my practice, just kind of thought we'd take in a legal pad or a computer and some documents and feel that we could extemporaneously get through it. Why? Because we had 7 hours, or depending what jurisdiction in, half day or 2 days. It just depends. But that's not the way to do it. You need to really think about it, and it will affect the outcome, because you're more prepared and know what you want to get. As we talked about earlier, going through the door of the house and getting the TV and taking it out, as opposed to just getting lost and not even knowing what's valuable.
Yeah. Yeah. And I agree with what you said. We really emphasize the importance of these depositions, especially in modern trial practice. It sounds like an incredible amount of time to devote, and it is. But in relation to the importance of a deposition, think of all the time and all the money that is spent over the whole course of the litigation. The deposition really is the focal point. So isn't it worth it to do it right, to really do it right?
Yeah, I agree. Exactly.
Well, one of the great things about your books are the concrete examples that you use. And your books are just loaded with them. Things from the deposition and grand jury testimony of President Bill Clinton in relation to the Monica Lewinsky scandal, and that's a famous, antitrust case involving Bill Gates. Other cases too, some of them less well known. And that's one of the things that I think really sets your book apart is that fine-grained analysis that you give to real-world examples. And I was just wondering if we could go through just a small handful of those to highlight some of the problems that frequently we see in depositions and how lawyers ought to handle them.
Yeah, that'd be great. And I just love real examples. I don't like teaching from hypotheticals because I just don't think they're as memorable or as effective.
Well, one issue that I think every attorney who's taken some depositions has encountered is the forgetful witness. The witness who suddenly has a bout of amnesia right in the middle of the deposition. And it can be a maddening experience, and I think it can tempt the examining attorney into doing some dumb things or taking the deposition in the wrong direction. They can sometimes end up getting played by that witness. So I want to talk about a clip from the deposition testimony of Don Wilson, who was the mayor of the city of Flint. This is from some years ago. I think a lot of us now think of Flint, Michigan as the locus of the Flint water crisis, which it is, but this is unrelated to that. This is a prior issue with kind of a big personality, controversial mayor of the city of Flint from some years ago. So I want to play a clip where he suddenly gets a bout of amnesia.
Do you recall, Mayor, what the circumstances?
I don't recall. Like my answer said, I don't recall.
You really don't remember what you were charged with?
No, sir, my answer is I don't recall.
Okay. Do you remember the name of the police department that charged you?
No, I don't.
Were you living in Michigan when you were charged?
I was.
Were you living in the city of Flint when you were charged?
Yes, I think so.
Where were you employed when you were charged?
Sir, it's been 40 years ago. I don't know.
You don't have any recollection?
Sir, please. Listen to me real close. No. If I tell you I don't know, don't ask me again.
Okay.
Okay, thank you.
Do you have any recollection of what the events were that gave rise to the charge?
I don't recall.
Okay. Was the conviction disturbing to you?
I don't recall that either, sir.
Really? You don't remember if you were upset?
It's 40-some years ago. I don't recall it.
Did you go into a courtroom as a result of the charge?
I think I did, yes.
Do you remember if you did any time in jail or prison?
I sure do.
Okay.
I remember that part.
And what do you remember about that?
I was sentenced to, I don't know, a certain length of time in prison. I do remember that.
Okay. So you remember being placed in prison for a specific sentence?
That is correct.
Shane, can you tell us, what should we take away from that clip of Don Wilson?
Maxwell, I liked what you said at the intro that a lot of attorneys get frustrated when there's a forgetful witness. What we need to remember is when they're forgetting, easily remembered facts. That's the gold nugget that you're trying to get, just to show that they're not credible. They don't remember something that they should. And in this clip, the portion that you played and the rest of it, he's just being questioned on whether he ever remembers being convicted. And it winds up that he actually served time. I forgot how many months in this prison, but the idea that you would forget serving time in jail, no matter if it was 10 years ago or 40 years ago, he's not credible. And the reason that he says, not the reason, but the fact that he says, I forget, don't remember, don't ask me about that, just shows that what? He does remember, and it's through that lens, it slants the rest of his testimony by getting that nugget that he doesn't remember something that he should very easily.
And for the examining attorney, I mean, watching this clip, he keeps his cool, he stays calm, he just continues to ask the questions, because sometimes you see in a deposition an attorney who will want to confront the witness and say, come on, how could you possibly forget? And he doesn't go there. And I think I hear you saying the implausible testimony is enough. You already got your nugget. He's doing you a favor by feigning forgetfulness.
And I always remind attorneys when I'm consulting, hey, keep it professional, not personal. And if you look at it that way, you're never going to get off your game by getting into an argument with the witness. And it doesn't make you look good. It just gets you off focus. So keep it professional. And also, Max, the attorney was very well prepared. If you're not well prepared, you can't really handle the forgetful witness because you don't know the details of what they should remember. And so you have to be prepared, and this attorney was.
Yeah, and I think there's another point in there, too, of know when you've won or know when you've scored your point. I think sometimes we come in with our outline, I want the witness to say this, and they don't say that. Instead, they say, gee, I don't remember any criminal proceedings because that's 40 years ago. Okay, you already won. Maybe it wasn't what you're looking for, but you certainly made a point that's going to help you a lot.
I agree.
Yeah. Well, the next clip is maybe a somewhat related issue that we often see in depositions, and that's the evasive witness who's not being forgetful, but who just won't answer the damn question. Bill Gates, in this clip, appears to be the master of evasion, and I'm just going to play a portion of really a much longer clip.
I do want to move through this as quickly as possible, but I must say that I think your answers are non-responsive and rambling. That really should be the case. I'm just letting you know that this is going to take much longer line of effort. And I would pose my question again because I think your answer was not responsive. Do you have any understanding as to what Mr. Siegelman meant here by his reference to Windows distribution being our one unique and valuable asset?
Was that the question I was asking?
Yes, sir.
Can you read me back the previous question? Or maybe there's some understanding. When you said, do you understand what he meant? I thought you were asking about his email as a whole.
Let me ask it for the third time now, see if I can get an answer. Do you have any understanding of what Mr. Siegelman meant when he referred to Windows distribution as our one unique and valuable asset?
I think the Marvel Group, in their search for what they could do to get millions of users, in this particular point in time, were thinking about making it easy to sign up through the Windows box, being something that would be helpful to them, and therefore an asset for the Marvel Group in what they were doing.
Do you understand that Mr. Siegelman, in his reference, had in mind a large market share that Microsoft has with respect to operating systems?
I don't see anything about that in here.
Yeah, it's not an understanding.
Hey, Ross isn't involved with the Windows business. He's involved with the Marvel business.
Without reference to this document, Mr. Gates, do you believe that Windows distribution is a unique asset that Microsoft has?
What do you mean when you say Windows distribution there?
Do you understand what Mr. Siegelman meant by the phrase Windows distribution in this email he wrote to you?
I think he means, I don't know for sure, I think he means including an icon on the desktop for access to Marvel.
So this was the first 2 minutes out of a longer clip of 7, 8, 9, 10 minutes, which of course is part of a longer deposition, where he is doing everything he can not to make any admissions about this phrase, unique and valuable asset. Can you give us a little context on that and what we should take away from that clip?
Yeah, I think the main thing to take away from it is that Bill Gates is obviously brilliant, and David Boyce, who's taking the deposition, is just relentless in asking the question until he gets the answer he wants. So it just shows you how prepared the witness is. And again, you find the witness is evasive, just repeat the question until they answer it. And secondly, the evasion is another gold nugget. So that's a win. Just the evasion shows that the witness thinks that there's a dangerous zone that they're in and they're trying to get out of it, so they evade it. And you're never going to get a witness to admit to wrongdoing, admit to a crime if it's a criminal court or anything like that. This isn't A Few Good Men or whatever the old movie or show you want to point to in Hollywood where this happens, right? In the real world, all you're trying to do is get them to show that they're not believable on a small point or a big point. If you can get some credibility wins, that's perfect. Don't try and get the admission. And again, you'll see that the attorney wasn't getting personal, just very professional and not religious cruel.
As I understood this segment, the whole point of this, quote, unique and valuable asset thing is Bill Gates is trying to avoid admitting that Microsoft regarded this product as unique because they're being accused of bullying others in the marketplace because they're the only one who had this thing and they're excluding others.
Right.
Right. And so he wants to say anything he can, but admit that. And I think one of the most powerful things about it is he dissembles and he dissembles, and then finally he still just has to admit it, which makes it even worse.
Right. Yeah. So I think the reason for that, it was in a email or a press release, that statement. So David Boyce had him, and he just kept patiently re-asking the question until he got the answer he needed.
Is there a point in an exchange like that when the examiner should simply move on?
I think never. I think you're entitled, well, I shouldn't say never, but you're entitled to get an answer to a simple question if it's fair. These questions were simple, they were fair. Max, a good reason to move on is if it's not that big a point.
Mm-hmm.
And if they're being evasive or forgetful on a minor issue, why waste your time getting to the bottom of it when you have bigger points to get out of the deposition? So I think that's what's going through my mind when I'm either trial consulting or doing it myself. How big a point is this that I'm trying to make? And if it's a big one, yeah, I'd say there 5 minutes to get the answer by repeating the simple question I've asked. If it's a minor point, move on because there are other battles to win and don't worry about that. A lot of us get very personal and not professional, and we get sidetracked, and then an hour is gone and we wonder what happened. Well, you got sidetracked. That was the whole point.
And maybe there's a difference here between the forgetful witness. With the forgetful witness, the witness is doing the examiner a favor by being forgetful in certain circumstances when they can't recall something that obviously they do and should recall. But maybe the difference here is they're not purporting to forget. They're just not answering you. And so it is more important to not let them play you like that and get the upper hand, not out of principle, but because if it's a very important point, like you said, you have every right to get the answer to a simple question.
I agree, yeah.
The next clip is a very famous clip. Most of us have probably seen of President Bill Clinton.
Hands an affidavit, which they are in possession of, saying that there is absolutely no sex of any kind, in any manner, shape, or form with President Clinton. That statement is made by your attorney and by Judge Schuster or Victor Round.
That's correct.
That statement is a completely false statement. Whether or not Mr. Bennett knew your relationship with Ms. Lewinsky, the statement that there was no sex of any kind, in any manner, shape, or form with President Clinton was an utterly false statement. Is that correct?
It depends upon what the meaning of the word is.
Yes.
If is means is and never has been, that's one thing. If it means there is none, that was a completely true statement.
Shane, this was a very well-known clip that we've all seen many, many times. What is your takeaway from this little bit of testimony?
One of the guidelines I give attorneys going into depositions is acronym CROSS, that you can question a witness on C, credibility, R, restrict damaging testimony, O, an outrageous statement, S, get a prior inconsistent statement, or just ask some questions that will support your case. And this clip is the O of CROSS. It's just an outrageous statement. And if you get that, it's better than an admission in a lot of ways because it gets the jury or the fact finder just angry that someone has come up with an outrageous answer instead of a correct or truthful answer. So when he says it depends on the definition of what the word is, it's just hilarious. It makes you smile. It shows he's dodging. It's a win. And actually, President Clinton was technically kind of correct. It depends on what the meaning of the word is. Mm-hmm. But in the setting, it just was laughable and it went viral. And it just showed his evasiveness and not being candid on these types of questions.
Yeah, I think his point was, look, I wasn't lying because this happened in the past, not in the present. Okay? You didn't say was, you said is.
Exactly. And if he'd said it that way, Max, it would have been a lot better. But when he said kind of with a smirk, he lost the credibility battle.
The expression on his face during that clip is priceless. It's like he knows.
Right.
It's like he knows he's being disingenuous. Right. I think it's also a good illustration of you can be too smart for your own good in a deposition.
That's a great point. Maybe should have been the title of that section. That's very profound.
And then one other one, there's so many examples. This is another one that's maybe not as famous to non-lawyers as the Bill Clinton example, but many lawyers I think have seen this clip online. It's a clip of involving a bunch of attorneys, including Joe Jamale, who is one of the most successful trial lawyers of all time, very famous Texas lawyer.
And was that your title during your entire stay in Texas City?
Texas City, yes.
Don't talk over each other.
After you left Texas City.
Let me ask a question here.
Yeah.
You represent this guy or not?
Well, you.
My name's Tucker, and I represent Ayrshire, and I just want to know you represent the guy or not. I'm getting, if you don't represent him, you don't have any right to be making any objection. If you do represent him, tell us so.
Watch speaker mouth shut. I'll do what I want.
No, you're not
Oh,
going to
yeah.
do what you want.
Oh, wait.
No, you're
No,
not.
you're not.
Yeah, I am.
That's
Make
bullshit.
whatever objections I want to make, and I'll make them as loud as I want to make them. Now, you just shut your mouth and we'll keep the record straight.
Don't tell me to shut my mouth, boy. You may be big, but you won't see how bad you are. Come on.
And I wouldn't try that, Ed. Are you threatening to fight?
Hold on just a second.
No, I want to know who's fighting. So we're going to be outnumbered, Ed.
Hold on just a second.
No, you got a big mouth. Now, you did. You need to either represent the man or not.
I'm
Not tolerate
representing
him.
Monsanto, and I
But
made
you're
an
not-
objection on the record.
Then you're not entitled to be his lawyer then, okay?
I'm representing the man.
Well, you're
There's
trying
an
to be.
objection on the
And
record.
another thing,
tell
you
me what
don't.
I'm trying to do.
Yeah, I'm going to tell you something else. You don't run this deposition. You understand?
To you, Joe.
You watch and see. You watch and see who does. Big boy.
I'm telling you, Joe.
Oh, you ain't telling me a goddamn thing.
Whatever objections I
You can make your objections and keep quiet. See?
No,
But don't be telling another lawyer to shut up.
Don't be
That
telling
ain't your goddamn job,
That's not
fat
your
boy.
job. Mr.
Get back.
Cherokee.
Now you said before you have an incipient. What do you want to do about it, asshole? Oh, I'd like to knock you on your. Well, come try it. Come over here and try it, you
Wait a minute.
dumb son of a bitch.
Wait just a second.
Come over here.
Hold it.
Hey, wait a minute. Hold on.
All right, Shane, have you ever had anything like that happen to you, or have you ever seen anything like that happen at a deposition in your experience?
Never. I guess we've all had that one or two depositions that went off the rails, but nothing as loud.
Not quite that extreme.
Not that extreme. So I think that's why this is so famous. I think, though, it's a great teaching point. Again, just going back, I harp on this principle, keep it professional and don't make it personal.
Mm-hmm.
And that's what happened. Everyone's just got all these egos and they're fighting with each other and not asking a simple question. And the objection was kind of not frivolous, but it didn't matter. So why not just move on and ask the questions? But you got derailed pretty quick.
Yeah, it sure did. And I'm going to play devil's advocate here, and I'm not endorsing any of the words that came out of Joe Jamel's mouth. But my reading at it is he was the one person in the room who was not emotional. I felt like it was calculated and that there was a strategy behind what he was doing. Not a strategy we should necessarily adopt, but certainly consistent with his brand.
That could be very right. Yes, I never interviewed him about that, but that could be very true. And maybe it was to distract the other side, and it could have been very calculated.
And seeing the witness get that riled up and that rattled and ready to come to fisticuffs and have to be held back. I've had depositions gone off the rails. I've seen them go off the rails, but nothing quite that extreme. Well, that's just a handful of great examples. I just wanted to kind of wrap up. I was wondering if you could give some insight on common mistakes that lawyers make in depositions. What are some things that you see that lawyers do that cause depositions to go awry?
I'll add three things. So the person taking the deposition is not prepared. Secondly, the person defending the deposition has not prepared the witness well enough, or maybe barely. Max, a lot of attorneys, if the deposition's at 9 in the morning, will say, come to my office at 8:30, maybe 8 o'clock.
Yeah.
I'll go over the deposition topics with you. And your deposition will start at 9. And that's just crazy. You at least need one meeting a few days before the deposition. And I recommend best practices are at least 2 meetings. The first meeting is just kind of, hey, what's going on? What are your fears and concerns? And the second meeting is more of a prep meeting. So one is the person taking is not prepared. 2, the person defending is not prepared. And then 3, the person taking it, I think the most common mistake they make, they're not listening to the witness's answers. They're caught up in their next question, what's going on. And if you listen, you can find out where to attack better by watching their body language. Is she hesitant? Is she speaking too quickly? Has she made an exaggeration? And then you throw away your outline and you just go after that and maybe come back to your outline later, but don't miss these opportunities because you failed to listen.
Yeah. And I think that goes hand in hand with preparation. You can't do that. You can't be in the moment like that unless you have really, really prepared and learned the documents backwards and forwards and have a very clear idea of what your objectives are for the deposition. We've had remote depositions for a long time, but since the advent of COVID, they've become a part of regular practice. In some courts, in my experience, they actually have a preference for Zoom depositions, and it can, if you want to take a live one, and actually you're going to have to fight for it. What are your thoughts on remote depositions versus live depositions? Do you think a lot is lost, or do you think it's okay? And I don't know, just what are your general thoughts on that more recent development in trial practice?
I think the big plus, right, is it certainly saves on costs of travel and everything else. So I think that's wonderful. I think it also has increased, obviously, having them recorded on video, which I'm a huge believer in.
Mm-hmm.
I think an oral deposition without a video is almost useless because it doesn't reveal anything about the witness's tone or body language when they're answering a question, which can go a lot to credibility. And, as we saw earlier, if there's a long pause in an answer, that's not captured in a transcript of a deposition, but it's certainly captured on video. Those are the big pluses. The quality of the recording is not as good as an in-person deposition that has been videoed. That's something that we need to think about. If you think, well, I'm going to use this Zoom deposition in a trial, you need to really think about the quality of that recording and how it's going to play in a courtroom. And then third, it's a live deposition. It gives you the advantage, with a lot of documents that can be a bit cumbersome to do over a Zoom deposition. And it just takes a lot more thought, and I think it'd be kind of cumbersome to do. So just consider those factors, and I'm all for Zoom depositions. They're certainly here to stay.
Yeah, they're here to stay, and they certainly have their place. And like you said, they add to convenience and efficiency, and I think have become an important part of litigation practice. What about judging demeanor? Do you have any issues with judging credibility and demeanor, or maybe building rapport with a witness when that's appropriate during a deposition? Do you find those to be challenges or issues with Zoom depositions, or do you find those pretty readily surmountable?
Yeah, there's definitely a problem in judging credibility over Zoom. One thing is you only see maybe, could be just from their shoulders up, depending on the setup of the deposition. And a lot of body language is conveyed from the waist and the legs and everything else. You're missing the torso a lot of times. Studies have shown that there's a lot to be gained from judging someone by being in person with them. It just doesn't show up on a two-dimensional TV screen. There's just no way to get a complete feel for someone's credibility over a Zoom as you would live. So they're all calculations, and you need to weigh them and decide what's most important.
Sure. Just one more set of considerations to weigh. This has been a great discussion, super insightful, and I know we're just scratching the surface. Let me just wrap up with one question. If there's one thing that lawyers can do to elevate their deposition game, what would that be?
Wow, so I guess I've already mentioned this idea of being prepared, so I think that would be kind of the one thing. But let me give you a couple insights on being prepared. It's knowing what the bottom line message of your case is. That is one sentence that has the theme of your case and why you should win. It's one thing just to be prepared and kind of know everything you know about the witness, but how does that fit into your overall case strategy? When I call the bottom line message, and when I'm consulting, I spend a lot of time on this because it takes a lot of time to come up with one sentence that has a theme of your story and why you should win. It's a fluid statement. It's been changed throughout the depositions you take, but you need to start with one and go into deposition with it. And then if it changes, fine, it'll change after a couple of depositions and more discovery. That's what will win you the mediation, the summary judgment, and ultimately the trial, if it goes that far, is having a case strategy where you've been able to ask the right questions at the deposition in order to win.
Yeah, that is so important. And is that safe to assume that's something you start hammering out from day one?
Yes. Yeah. Right. And then the other thing, Max, which I like that you're probably hinting at, is that you got to get the jury instructions to know how you're going to win or lose your case. And from there, you got the instructions, and now you have a bottom line message day one. The instructions won't involve, but your bottom line message will. And a lot of lawyers don't have the time to do it. You've got to make time. It's a priority.
Yeah, for sure. This has been super insightful, practical. I've enjoyed it. Where can listeners find you and learn more about you and what you do?
Yeah, the easiest place is my website, ShaneRead. It's my name, ShaneRead.com. And my book's on Amazon. But Max, I've really enjoyed being on this podcast with you. I've learned a lot from you, which is why I enjoy doing this and was looking forward to doing it. So thank you for having me.
Well, I appreciate that so much. And again, I cannot recommend your books strongly enough to listeners. So thanks for writing them. Thanks for being on this podcast. Thanks for sharing your insights today on the Litigation War Room.
It was a pleasure. Thanks so much.
You have been listening to the Litigation War Room with litigation attorney Maxwell Goss. Maxwell Goss brings forceful advocacy and creative solutions to trade secret, IP, and business cases in Michigan and around the country. For show notes and more episodes, please visit us at thelitigationwarroom.com. If you enjoy the show, please be sure to subscribe, rate, and review wherever you get your podcasts. Thank you for listening. The Litigation War Room, including the podcast and all website content and social media, is for informational and entertainment purposes only. This podcast does not provide legal advice and does not give rise to an attorney-client relationship. All views and opinions expressed on this podcast belong to the guests expressing them and do not reflect the views and opinions of the Litigation War Room.